Excessive pretrial detentions are not, as required in international human rights law, necessary or proportionate in order to secure the appearance of the person at proceedings or to facilitate the shortest time possible. This thus offends a framing principle of all international instruments on human rights, as embodied, for example, in Article 1 of the American Declaration that every human being has the right to life and liberty. The excesses of the remand system also violate the right to a fair trial with a brief procedure as enshrined under Article 18. The Inter-American system has been clear that fundamental rights are violated when undue delay in bringing cases to trial occurs, particularly in situations when accused are in pre-detention. These rights are designed to avoid keeping people too long in a state of uncertainty about their fate, and if held in detention during the period of the trial, to ensure that such deprivation of liberty does not last longer than necessary in the circumstances of the specific case. Thus, it has been consistently held that persons are not released pending trial must be tried as expeditiously as possible. In the Trinidad and Tobago case of Hilaire Constantine, Benjamin and others, the Inter-American Court pronounced on these issues with regard to a murder accused who alleged due process violations arising from alleged delays, deficiencies in their treatment and condition of detention, and denial of access to legal aid. The court found violations of the right to be promptly brought before a judge, a trial within a reasonable time, and a fair trial. Municipal courts have tended to accept without question the state's defenses of scarce financial resources in these challenges. For example, in Sukamani and the DPP, the High Court said, "The problem of institutional delays is a complex one, to which there may be no simple ready-made solution, and the scarcity of financial resources is clearly a factor to be taken into account. The court is entitled to take into account the prevailing system of legal administration and the prevailing economic, social, and cultural conditions that are found in that particular country. Yet, the international human rights law today imposes stricter standards. While we accept that scarcity in resources is a legitimate factor, it is neither the only reason for delay nor is it insurmountable. Just as important are the structural deficiencies and attitudes in the system which mitigate against better justice. Due process of law as protected under Article 26 is viewed as an umbrella right, even in our courts. It safeguards other fundamental rights and freedoms, and its assertion that every accused person is presumed to be innocent until proved guilty is key to the securing of a fair trial and the protection of liberty. International law has required that deprivation of liberty must be an exceptional measure supporting the presumption of innocence principle which governs the judicial process and is a right owed to anyone charged with a crime. Where the accused is detained during the pre-trial process and the case takes extremely long to go to trial, the presumption of innocence is jeopardized. Indeed, excessive periods of pre-trial detention assumes instead that accused persons are guilty, not innocent, and thereby contravenes international standards. As the Inter-American Court stated in Ricardo Canis and Paraguay, the right to the presumption of innocence is essential to the effective realization of the right to a defense and accompanies the accused throughout the trial proceedings until a judgment determining his guilt is secured. 13 years remand has been sufficient to find human rights violations of Articles 7 and 8 of the Convention. The infringement against the presumption of innocence is exacerbated for women remandees linked to domestic violence, since until the matter reaches trial, they are unable to raise lesser charges to which they may be entitled, such as self-defense against abusive partners, slow burn provocation, cumulative provocation, diminished manslaughter, or temporary insanity due to the well-documented impacts of long-term abuse. All are charged and remanded simply for murder. Despite these potential defenses, these women find themselves deprived of their liberty for extensive periods due to the slow pace of justice. Thus, in the structural paradigm of vulnerability that confronts women, women are doubly disadvantaged. First, the state fails to adequately protect abused women, and subsequently, the criminal law and judicial system further prejudices women who kill their abusive partners, treating them like cold-hearted murderers. The delays in gathering evidence is one factor in the problem. However, international law has consistently noted that delay due to evidence gathering is not enough to justify the lengthy passage of time between arrest and trial, as the Human Rights Committee noted. It emphasized that a lack of adequate budgetary appropriateness for the administration of criminal justice does not justify unreasonable delays. Institutional delays such as those caused by lack of resources are also inadequate in justifying lengthy pretrial periods. Several other factors cause excessive pretrial detention. Some are structural, institutional, or evidential in nature. Attorneys themselves blame the slow pace of producing evidence for preliminary inquiries and preparation of trial, particularly with the small pool of criminal defense attorneys who, it is claimed, tend to put off all other competing matters when on a trial, requesting a series of adjournments by court, which are usually granted and effectively stall other criminal cases under their management. The limited number of courts are also blamed. Further, the DPP has complained that his office lacks financial autonomy, which leads to severe staff shortages and even basic office supplies and facilities needed for expeditiously dealing with cases. Under the broad rubrics of due process and the right to a fair trial, the right to bail is also prescribed. When examined with the parameters of remand, further injustices are apparent. Bail is typically not available for murder charges. Where bail is available, it may not be affordable. Bail issues are a constant complaint among remandees. Problems are more than the cost. For example, prisoners at Golden Grove said that they were brought before the court infrequently for bail hearings. Prison officers admitted that there was a period of 3 months where transport vehicles were unavailable. Consequently, no remandee was able to attend bail hearings. If remandees cannot access bail, they cannot pay bail. We believe that the bail system should be reassessed and reformed as an alternative to remand in Trinidad and Tobago. These deficiencies also make alternatives to pretrial detention, including electronic monitoring, permitted under law but not implemented, even more important. The issue of